Welcome, folks, to this Wednesday, May 13th, 2026 meeting of the Harpswell Board of Appeals. I'll go briefly through our procedure. First off, I'll introduce the members of the board. Starting from my left is Steve Bruall, Steve Musica. I'm Ned Simmons, chair of the board. To my right, Pat Lawson, and Caldwell, who is an associate for this. And since David Zemnorowski, one of our regular members, is not here this evening, I'll appoint Ann a full voting member for the evening. I'll note we do have a quorum. We have a full five-member complement. On the agenda this evening, we have a administrative appeal by Archer Holdings LLC. We'll be doing our annual election of officers, and we'll be considering the minutes of our previous meeting, which was July 30th, 2025. Anybody who wishes to, first I would remind folks, if you think you may want to speak this evening, in order to help the recording secretary identify you, it would be helpful if you would sign in on the sheet by the door over there. If you do wish to speak, just please step to the microphone at the podium and identify yourself. Any questions and comments should be made through the chair and not amongst yourselves or directly to other members of the board. In general, the applicant will have an opportunity to present their case first. Any other interested parties that are in attendance will also have an opportunity to speak. Also, the CEO and other town officials will have an opportunity to speak. If you feel that you may have any reason to appeal or disagree with any decision taken tonight, you should, in order to preserve your rights of appeal, you should at minimum step to the microphone, identify yourself, and state the nature of your concerns. That's in order, if you felt as though you may want to take any decision we take to court or ask us to reconsider. I would note that any verbal representations you make here will become a part of the record. I note that we did have a site visit on Monday morning. The applicants were present, as well as all of the members seated here. All the board members seated here this evening were at the meeting as well, or the site visit. I'll briefly go through the application file. We have a memo noting delivery from Perkins Thompson representing the applicants, noting that they, there's a transmittal memo, I guess, for the application dated April 14th. We have an application that was received on April 15th, and I guess we'll get to the dates later on when we get to the date of the matter being repealed. We need to determine whether this is timely or not. Some further correspondence from Perkins Thompson regarding the background and detailing some of the concerns of the applicant. We have a boundary survey by sight lines outlining the proposed activity on the property, which is the division of a lot. We have a letter from the Codes Enforcement Office to Archer Holdings dated March 6, 2026. We have correspondence from Sightlines dated March 12, 2026, detailing their argument in favor of allowing the lot division to go forward. We have a letter of authorization from Archer Holdings to their attorney, allowing, authorizing the attorneys to represent them in this matter. We have a request for reconsideration from Sightlines to the CEO, asking if they reconsider their decision to deny the division of the lot. We have a memo from the Codes Office dated March 6, 2020. Is this I think this is a duplicate of what I saw previously. I think I have duplicates of much of this stuff. Have a deed or a property description of the proposed division. It's not a recorded deed. I believe this is a property description of the lot, the proposed lot that's intended to be split off. We have more correspondence from Sightlines to the Codes Office discussing the division. I think email regarding a septic system permit from John Hensley to the Codes Office. A subsurface wastewater disposal system application dated January 15th, 2025. And a site of, well, and it seems to have been approved or signed by the site evaluator. I'm wondering if that's a typo above. It was approved by the evaluator or signed off on by the evaluator on January 13th, 2026. Plans of the proposed wastewater disposal system. Description of the wastewater disposal system. A subsurface wastewater disposal system variance request filed on January 13th, 2026. And that's the gist of what I have here. I guess I will note that the filing was timely, since the application was filed on April 15th, and the memo, the disputed memo, is dated March 6th. So within the 40-day, I think it is, window. I guess, appears to me it's complete application, is that?
Does to me.
Don't see anything missing.
Nope.
Amy?
Mr. Chairman, I just wanted to identify myself and my role here tonight. I'm not sitting up there at the table. My name is Amy Chow. I'm the town attorney. I'm from Drummond Woodsum. I was asked to attend to assist the Board of Appeals with any questions that you might have regarding procedures or interpretation of your ordinance. And if you reach a decision tonight, to assist you in the development of written findings and a notice of decision. That's my role here tonight. I have not conferred with the code enforcement officer regarding this matter. The letter went out, and I was asked to attend. if I can be of assistance.
You're representing the board.
I'm representing the board.
You're free to sit up here with me.
I'm
That's
happy to
more
stay where I
convenient.
am. If you want me up there, I will reluctantly,
wherever you're
but I
most
just wanted to
comfortable.
identify my role tonight.
Yeah.
Thank you.
I assume there's a attorney here representing the applicant. If you'd like to speak to the matter.
Absolutely. Good evening, Chair Simmons, members of the board. Brandon Mazer, attorney at Perkins Thompson, joined by my associate Emily Arvizu, representing Archer Holdings. And I think you've met, we've got Kevin Clark here, as well as Kelsey and John, who are the owners of the Harpswell Inn. As hopefully a way to try to visualize and simplify things, we have created, and I wasn't sure what the technology here was, so we created paper slides to help walk us through our discussion this evening. So if you'll allow me, I'd like to. No, thank you. And then I'm also going to circulate the plans that are also blown up here, but just so you have them in front of you.
Guess we thought there was going to be more.
So again, Brandon Mazer here for the applicant. As a way of background, I know maybe we spelled this out in our appeal, but I think it's good to review. We're talking about a lot split here at 108 Lookout Point Road, which is the current Harpswell Inn lot. And as you saw in the Exhibit A of the appeal and here, the proposal is to break it into two lots. So we're referring the two lots to throughout the presentation as the remaining in-lot and the proposed lot, just to keep everyone on the same language. So as a bit of timeline, the chair went through the timeliness, but this all started back in January where Kevin, on behalf of Archer, submitted to the Code Enforcement Office the initial proposed lot division survey. And there was some discussion going back and forth. Fast forward to February 26th, Mr. Clark submitted a revised plan with the clarifications the CEO requested, including floodplain, square footage of each of the proposed lots, and impervious coverage of the development. March 2nd, 2026, Clark attended a meeting with the CEO regarding the revised plan. March 5th, Clark submitted a further revised plan following the March 2nd meeting. And then on March 6th, Archer received the decision from the CEO denying the proposed lot split. So the denial itself, which is included in your packet, stated that the basis for the denial is the proposed lot split does not meet today's minimum lot standards. And then the denial further describes those requirements as follows. Pursuant to the Harpswell Shoreline Zoning Ordinance 15.1, the minimum lot size is determined by two factors, 40,000 square feet and 150 feet shore frontage. And then the denial further states that if Archer Holdings were able to obtain the necessary frontage from one of your abutters, then we could reconsider the proposed lot split. On March 12th, Mr. Clark, on behalf of the applicant, sent a request for reconsideration after further review of the ordinance, given the fact that Section 15.1.3 of the Shoreline Zoning Ordinance provides for the minimum shore frontage to be governed by the average shore frontage of 3 lots on either side of the lot to be divided. And that's, I think, the crux of what we're going to walk through this evening. On the 13th, the CEO responded to the request by asking Clark and the applicant to present the issue to the Board of Appeals, and that's what we're going to do this evening. So the argument is relatively straightforward. We believe that the proposed lot split meets the minimum standards under the shoreline zoning ordinance when the sliding scale established under section 15.1.3 is properly applied. So if you turn to slide 2, section 15 of the shoreline zoning ordinance sets out minimum lot standards for lots within the shoreline zone. So slide 2 is what we're going to walk through step by step for each of the two resulting lots using the minimum lot standards table in 15.1. So we've got the remaining in-lot. And if we look at slide 3, this is a screenshot of the town's online zoning map showing, and I'm sorry for the feedback, depicting the 108 Lookout Point Road falling within the commercial fisheries 1 and 2 zones. And I think that's important here for this remaining in-lot. Because if you turn to slide 4, for the remaining in-lot, the lot falls within commercial per principal structure, which we've highlighted on slide 4, because it is a commercial property, and from there it falls within the second subset of within shoreline zone adjacent to tidal areas zoned for commercial fisheries 1 and 2 for commercial uses only. So for properties that fall within the second subset of commercial properties, there are no minimum lot area or minimum shore frontage requirements as shown in this list. So the remaining lot that the inn sits meets the frontage. Turning to the proposed lot that does have frontage, the applicants are proposing residential use. So as we've highlighted on slide 5, it's undeveloped currently, but while it's zoned commercial fisheries 1 and 2, the minimum lot standard table specifies that the minimum standards only apply to commercial uses. So we've now shifted to residential use. And as such, those need, that would fall within this category, residential per dwelling unit on the minimum lot standards table. And that requires 40,000 square feet and a minimum shore frontage of 150, except at the header, and we put a little yellow star, minimum shore frontage has a footnote 2. So if we go to slide 6, we've then excerpted the footnote. And with respect to the minimum lot area, footnote 1 states see 15.1.1 for land that cannot be included in the lot area. And I'll represent to you that the proposed lot meets the requirements under 15.1.1, and the CEO has not raised any issue with respect to those requirements. And then turning to the shore frontage, footnote 2 directs us to see section 15.1.3 for the sliding scale. The sliding scale is excerpted on slide 7 for your ease. And it provides that lot frontage in the shoreline zone is governed by the average shore frontage of 3 lots on either side of the lot to be divided. Lots shall be either not less than 100 feet frontage or 150 feet frontage or greater of frontage. So admittedly, when Emily and I looked at this and we looked at it with the applicant, the language is rough. But I think it provides some guidelines and examples. So then if we jump to that last paragraph that starts with hence, the section provides that if a parcel is surrounded by 3 lots, either side, averaging less than 149 feet frontage, lot can be divided into 100 feet frontage lots. By contrast, if a parcel is surrounded by 3 lots, either side averaging greater than 150 feet frontage, the lot must be divided into 150 feet frontage or greater lots. So trying to do this in plain language, our interpretation is that it means the minimum shore frontage for the proposed lot is determined by the sliding scale based on the shore frontage of the surrounding lots. So the sliding scale, and we've done this a number of ways, and I know at the site walk, Kevin was asked to try to measure it in a variety of ways, and we've done that. So on slides, we're going to kind of be flipping through 8, 9, and 10 now. Kevin provided the shore frontage data for the surrounded properties in the request for the reconsideration. They all, as you see, have less than the average of the three, depending on which three you take, and he did it both ways. We're at, we take lots 38, 34, and 32, located to the west is 114. And if you take lots 42 to the east and the two lots 38 and 34, you're at 145.6. Both cases, the average is less than 149 feet. So the ordinance allows for consideration of the properties on either side of the lot to be divided. If you look at lot 9, we've tried to do the math as many different ways as we can just to be perfectly safe and clear on what these averages are. So we did tax map, scaled from survey, tie line, hat, and the other tie line. And Kevin can go into his methodology better than, and probably you may want him to, better than the lawyer trying to explain it. But as you can see, across the board, we're all under 149 feet. But the bottom line is, regardless how you measure, the proposed lot meets the minimum shore frontage requirement of 100 feet per the sliding scale. So because the remaining lot, in-lot, and the proposed lot satisfy the requirements set out in 15.1 of the Shoreland zoning ordinance, we believe the CEO erred in denying the original permit for the lot split. And we request that this board vacate that decision and remand the application to the Code Enforcement Office with instructions to approve the lot division application. Again, happy to answer any questions and bring Kevin up if you want further explanations on how the calculations were different. He also updated, I think is it this one that you updated with the new? Expanded, yeah. So, happy to take any questions.
What about the lots beyond lot 42? I mean, depending on how you interpret this, if you were to interpret the language, which admittedly is pretty poor, if you were to, and I think it comes down to how you construe the either in there, in my mind anyway. What happens if the ordinance says that the three lots on both sides of the property have to average 150 feet total? Then we would have to look at the lots beyond 42. And we don't have any, do we have any information on those?
I did look at that, and
Can
I
you
actually...
identify yourself, please?
Oh, sorry, Kevin Clark from Sightlines. I did look at that, because the next lot beyond 42 is Mitchell Field, which has a significant amount of shore frontage. However, the word is either, which either gives us a choice, and we chose not to include Mitchell Field.
I guess we'll decide what either means.
We'll let it, we can look it up.
I did.
Yeah, I think from.
Either is different than the each.
Yeah, I think the plain language of 15.1.3, lot frontage in the shoreline zone is governed by the average shore frontage of 3 lots to either side of the lot to be divided.
Yeah, see, I looked it up, and either means being the one and the other of two, which to me means same thing as either or, that you could, yeah, I agree, it's ambiguous, it's not well-written, but, one question I have is, and it's not clear to me what the procedure is with codes for dividing the lots, and maybe, Tim, can you speak to that for us?
I'm sorry, your question?
what's your procedure when somebody comes to you and says they want to divide a lot? I mean, it doesn't require
Well,
a permit.
basically is to look up the 40,000 square feet, and either it's 150 of road frontage or ocean frontage, one of the two, if it's interior or shoreline. And I felt that the sliding scale was too vague for this office to make, so
Yeah.
5 brains
Right.
are better than 2.
If it was clear.
Yeah, it's not,
If they-
I didn't feel
no,
that it was
no,
clear
if somebody
enough.
comes in with one that's a, easy
It's
decision,
easy,
then-
that's
then what
fine.
happens? Do you just stand back and let them do it?
Yes.
I mean,
Well-
there's no formal application or.
No,
permit
there
or
is not.
anything like that.
I usually talk to the surveyor, we get through it, they go and record it, it comes to Debbie's office. If Debbie has a problem with it, or she'll come into our office and recheck it, and we'll go over it again.
So
usually-
theoretically, somebody
usually-
could go and file a plan, and you wouldn't catch it until it came back after it was
Correct.
filed?
That's why normally surveyors come in and talk to us first,
Right.
which is great. It was too much vagueness, in my opinion.
I understand.
I didn't want to go there.
I guess I'm trying to get to what, depending on what decision we make, what the next step is. Do we
Hey,
just?
Because we felt the same thing.
In
If you
effect-
took 3 different lots, can you know,
Well, in
It-
effect,
it's not-
if we decide for the applicant tonight, we're just going to tell you to ignore what they do, right?
exactly.
In
Well,
essence.
we still have to get through the permit. The septic is not approved yet. The setbacks, I still want to now, and that we know that there's a tributary on the property right next to this that isn't shown here, because we were only talking about the survey, the land that they're talking about. We didn't know that there was a tributary until we did the site visit.
Yeah.
So there's other things, but the
that
permit
doesn't-
part for the house is different than making this a legal lot. So to me, it
That
was
is-
2
that-
different issues.
That has more to do with the use after the
Exactly.
lot's created. That doesn't prevent them from creating a lot and then
Correct,
dealing with those issues
correct. I was
later
trying to
on.
keep it separate.
Yeah.
All right.
Thanks. Yep.
I just want to, more for the record than anything, and to clarify, my understanding is that the sliding scale wasn't applied at all. So, and I think it's a minor nuance, but that he didn't take into account the sliding scale. For whatever reason, he didn't, which is fine. So I think this portion of the ordinance exists, so it needs to at least be applied. Now, if you have a different interpretation of how that reads, that's one thing, but I just want to clarify that. My understanding from the denial and from conversations with the code office, it was never taken actually into account to say one way or the other it was denied because it doesn't meet the standard wasn't applied at all because of that vagueness. And it's a slight nuance, I just want to make sure it's
That
clear.
was my understanding from the
Okay.
correspondence.
Okay.
Yeah. Any questions from the board, any of the?
Just, questions or comments?
Questions for the applicant or the
questions.
codes? No.
I have one question.
Yep.
The word either that we're battling over here, a little bit confused about, I'm looking at, that's the either that appears on slide 7, the excerpt you had there, okay. And so your interpretation of that is you can take the averages from either side of the, okay.
Correct.
Doesn't say each.
Or-
Which would mean you would have to take the average on both sides.
Or both.
Or both.
Yeah, yeah, okay. All right, thank you.
No, that was my question too. That was the first thing that I noticed was how vague
Yeah.
that was. And somebody's got to make a decision about. Yes, exactly.
I had a conversation with Amy earlier today on interpretation, and Amy, maybe now's an appropriate time for you to give us your guidance.
Margaret gave me a tax map, and I've lost it. Good evening.
On the board, if you'd like.
Oh, is it on the board?
Yeah.
Oh, no, You looking for the tax map?
Yeah, I have a copy.
Oh, you do?
In looking at your ordinance, I did see that there were two legal interpretation issues, two categories of legal interpretation issues that I think the board should grapple with. And let's start with the sliding scale, the interpretation of 15.1.3. So, I think we can all agree here that this language in 15.1.3 is not the picture of absolute clarity. 15.1, as you know, for lots that are being created in the shoreline zone that are adjacent to tidal areas, you need 150 feet minimum shore frontage. That is consistent with state mandatory shoreline zoning guidelines. So to the extent that 15.1.3 deviates from that, it deviates in a manner that is more lenient than or does not comply with minimum state shoreline zoning guidelines. 150 feet is the minimum shore frontage for shorefront lots created in tidal areas, adjacent to tidal areas, under the minimum guidelines, and there is no sliding scale provision under those guidelines. So that's some context. But looking at 15.1.3, I think one area that if you look at, it talks about the lot to be split. And I think we are talking about the lot to be split. I don't know if you can hear me. The lot to be split is 40, correct? And then what this says, if we look at the first paragraph, is lot frontage in the shoreline zone is governed by the average shore frontage of 3 lots to either side of the lot to be divided. All right, so if we just look at that, the 3 lots to either side to be divided would be on the southwest side, lots 32, 34, and 38, which in their letter they do address that. But the 3 lots to the northeast would be lots 42, 62, which is Mitchell Field and has a shore frontage of 1,620 feet, and lot 70-1, which has 350 feet. If you average out the 3 lots to the left or to the southwest of the lot to be divided, you get about 114 feet, which would be under the 149. And if you were to look at 15.1.3, arguably you can go as low as 100 feet. You can go under 150 feet. The standard rule is 150 feet. 15.1.3, I think you could look at as an exception if it applies, all right? So you have 114 feet on this side. If you're looking on the other side and you're grouping those 3 lots together, my calculation was you get to about 700 feet, all right, of shore frontage, average, in those 3 lots. Now, what the applicant has done is they've picked and chosen the 2 lots to the west, 34 and 38, and then they took 42 on the right. And I think a question for you is that even what this ordinance provision is asking you to do? If not, I think the language, looking at the second paragraph in 15.1.3, it's tough to read, but I'll try. A 200 to 299 foot lot, meaning a lot that has that kind of frontage, surrounded by 3 lots on either side averaging 149 feet or less frontage, could be divided into lots with 100 feet minimum shore frontage. I think all that's trying to say is, using an example, if you have lots that average, if you have 3 lots and they average less than 149 feet of shore frontage, then they're saying you can dip below the 150, but you have to be at least 100 feet of frontage, right? But I think it's important for the board to interpret the next sentence. if surrounded by 3 lots to either side with an average of 150 feet frontage or greater, the lot could not be divided. And I would submit to you that I think the importance is either. I think, Ned, you're correct that that's something you need to struggle with. But you also need to look at the word surrounded. Because if you were able to just say, hey, we meet it on this side but not on that side, right? Then why would this term have used the word surrounded? What this is saying is it's surrounded on either side by 3 lots on this side, 3 lots on that side. And one thing to look at is what was meant, that if you're looking at why this provision is in place, keeping in mind that it's not very well worded, I think the concept behind it is we ought to look at the neighborhood and the frontages, the shore frontages that are in this neighborhood in general, to see if this is in keeping with the neighborhood, right? And if every single lot around you, 3 to the left, 3 to the right, is a substandard lot, then you're dipping below 150, but not less than 100, makes some sense. I'm not trying to divine the intent of the drafters here. This was, I think Margaret can tell us when this thing was adopted, but it was in the early 1990s. And as best I understand, no board has interpreted what this language means or applied it, and no applicant has applied it. So if you're looking at 15.1.3, I do think it's important to look at, does it make sense to say that they get to go below the state minimum shoreline zoning guidelines, below 150, if they meet it on one side but not on the other? Or is the better interpretation that it says if it's surrounded by 3 lots to either side with an average of 150 feet of frontage or greater, the lot could not be divided? And in this case, you certainly are not surrounded on both sides by an average of 149 feet or less. You have on one side 150 feet or greater, and you have a provision that says if you have that, the lot could not be divided if you're surrounded. So you have to, I think you have to struggle with that. That's one observation I have. Another observation, which I don't think was addressed either by the code enforcement officer, but it was addressed in the letter, is the status of Lot 40 to begin with, and whether you can split the lot in reference to the section in 15.1, the reference to the exemption from all, from minimum lot size and from shore frontage. I think there's a slide here on this. Let me go to it. It is on page 4. Yeah, thanks. So keeping in mind that 15.1 is really looking at, when you're in the shoreline zone, it's how should the town, how should an applicant be guided when they want to create a new lot, right? And so I believe Lot 40, if I'm correct, is a legally not, when was that lot created? It was prior to zoning? No? Prior to? Okay. When was the commercial fisheries 1 and 2 zones? I have 2 questions. One is, when was Lot 40 created, and with the commercial in use on it? I thought your letter said it was prior to 1990. It was. When did shoreline zoning come in to Harpswell, in the 70s? I'm going to go with that, but you can correct me. I'm thinking shoreline zoning came into town well before 1990s.
I know there was shoreline zoning, at least as early as the mid-'80s.
So when this lot was created as Lot 40, it has 141 feet of shore frontage. That's less than the 150 feet that's required.
I believe the standard may have been less.
It may have been less.
That lot
Okay.
was split from 42 in 1990.
Okay. So I'm trying to get at the status of the lot with respect to its frontage and with respect to its use. All right, so I think what we've established is that it is a legally non-conforming lot with respect to its frontage, currently as it stands today in its undivided status. Because today, if you were to create a lot in this area, a brand-new lot, you'd need 150 feet of frontage, right? You're in a tidal area, you need 150 feet of frontage. This does not have that. I'll take you at your word, Kevin, that this was created at a time when it was compliant, so that makes it legally non-conforming. You're okay so far on that, right? Okay. And the inn has been on this property?
It was built in 1760.
Okay, so clearly legally non-conforming prior to zoning. When commercial fisheries 1 and 2 came into effect, I don't know when that happened, and Margaret maybe can school us on that, but when you look at commercial fisheries 1, which is the one closest to the water, right, first 75 feet, you have to be, the uses that are allowed in your basic land use ordinance are functionally water-dependent uses only, right? And commercial fisheries 2, I think you're allowed to have marinas, and you can have residential, of course, if you meet the residential per dwelling unit requirements. Correct. So when you look at 15.1 as a whole, I think you need to look at it through the lens of if someone were to create a new lot, then when are you allowed to use the exemptions from any requirement of minimum lot size or minimum shore frontage? And I think a reasonable interpretation, again, this is for you to look at and analyze, is if someone today were to come to you and try to create a brand-new lot in commercial fisheries 1 and 2 that was non-residential and that was commercial but not a functionally water-dependent or fishery use, that would be not a permitted use. It's my understanding as I read your ordinance, because the uses allowed in commercial fisheries 1 and 2 are limited as to the type of commercial uses allowed. So an in-use would not be allowed as a new use. No question, that's legally non-conforming as it stands today. But what happens when you divide the lot into like this? You've now created, this is a question for you, have you created a new lot, understanding that the old lot 40, before it was split, is legally non-conforming as to use and as to shore frontage. And it also is greater than 40,000 square feet. So that lot is fine. When you split it down the middle, not only should you be looking at the lot that gets created, that they want to put their residence on, but the lot that remains, that is in the shoreland zone and now has no frontage. So we have a shorefront lot, or we have a lot in the shoreland zone that that you have to ask, is 150 feet of frontage there? Is that required? Or should they get the benefit of this exemption? And I think one question for you to look at is, when you're creating a brand-new lot, the reason that the exemption was created for minimum lot size and shore frontage is that you want to promote commercial fishing uses, right, or water-dependent uses in your town, so that without reference to a minimum lot size or a shore frontage, right? You want to allow the fisher folks in town to do what they need to do and get to the water. The question is whether, if you're a grandfathered in use, whether you can then lop off half of that lot and create a new lot, and whether this section was, and this exemption that was, arguably adopted to promote to give relaxation of these standards to commercial fishing and functionally water-dependent uses, which the DEP also recognizes as a goal, that it would make sense to exempt those. But, so I think you have to ask the question and interpret 15.1 sub 2 under commercial per principal structure, when it says within the shoreline zone adjacent to tidal areas zoned for commercial fisheries 1 and 2, which you are in, right? And that it says for commercial uses only. And the question there is, was that intended for grandfathered commercial uses? Or are we looking at this through the lens of creating a brand-new lot with a new use, a new commercial use that's being proposed? And if you look at your land use table and your basic land use ordinance, those uses are limited. I don't know if I've been clear, but I think those are two issues that you may need to address.
I mean, this is, I know, and I don't remember the context, excuse me, but I know I've wondered about this in the past, the fact that, I mean, you do see lots in the shoreline zone, for instance, a lot behind another lot that isn't attached to the water in any manner. Is that a non-conforming lot, just by virtue of the fact that it's in the shoreline zone?
Well, I do think you have to look at that issue. I know that there are backlots in the shoreline zone. Are they new lots? Are they newly created lots is the question.
Right.
And if you're allowed to do that, you might then ask the question, what is the purpose of a 150-foot shore frontage requirement if you can back up other lots to it in a newly created manner and just create a right-of-way to the water? Can you double dip on your frontage is another way of looking at it. But that's for you to decide. I know I've thrown a lot at you, and I'm not suggesting, I mean, there's a lot of things to consider here. Yes.
I have a question, Amy. It's an example of how difficult this is to interpret. So there are, as I understand, in the shoreland zoning, a number of areas in that pink zone which have big residential sections in them currently. And if you had such a situation, I don't know what the zoning is, say, on the large lot to the north there.
The Mitchell Field lot?
Yes.
This lot.
Is that also in commercial zoning? We could use that for my question. But use that as an example, so that lot, or if there were multiple residential lots zoned commercial fishing too, and they had relatively large acreage and frontage, and somebody in that zone, which was in zone commercial fishing but used as residential, if they wanted to divide a lot and they had both the 40,000 square feet and the 150 shoreline frontage, that seems to me that that would sail through and not even be a question based on how the interpretation has been used. If that were the case, then it would seem inconsistent then to interpret the use of 15.1.3 considering the issue of the zoning, the commercial zoning, which is part of what I think I took from what you were saying. And that would create more inconsistencies as well in interpretation of this zoning law.
I do think there are multiple ways, and thankfully you're the board who gets to interpret this ordinance. But I understand what you're saying, and I do think it's helpful to look at this through the lens of what is the lot now and what is legally non-conforming about it, right? It's a lot that is legal and its use is legal, and it has 141 feet of shore frontage on it. If it's divided in two, you're going to get two lots, and you're not going to get 300 feet of frontage. You still have only 141 feet of frontage. And the question is, does the sliding scale help you? Should you apply it? Should you not? How should you look at 15.1? I think all of those issues are for you to grapple with. But I agree with you that your example, the bright line example, I think we probably all could agree on.
Amy, we spoke earlier about the issue of consistency. And I
Yes.
guess I brought up the issue of ambiguity, and I guess in my mind, I often have kind of a hierarchy in my head of what controls, and obviously the black and white language is first, and then, then you get into, well, what are the purposes of the ordinance, and what are is it ambiguous? And then way beyond that is, what was town meeting thinking when they adopted this, which I hate to
Right.
even consider, but I guess we spoke a little bit about ambiguity versus consistency.
Yeah.
I mean,
I can tell you that there is a section in your shoreline zoning ordinance, section 7, that you may want to look at. And it basically says when there is a conflict between two provisions that you, in an ordinance, you should apply the more restrictive one unless state shoreline zoning law provides otherwise. So if you're looking at ambiguity and consistency and conflicts, I probably would urge you to ask the question first, do we have a direct conflict between any 15.1 and 15.1.3, or do we not have a conflict? And then the question becomes, is 15.1.3 clear enough? Meaning you need to interpret what surrounding means and what either means, and whether you're supposed to group the 3 on the right and the 3 on the left, and if one of them is greater than 150, there's no division, or whether the opposite is true. So that would be it's not ambiguous, it's clear, but when we apply it, we come to a certain resolution. Then I think but the question then becomes, do you think 15.1.3 is ambiguous? And I do think I think you would want to ask that question. And I think there are a variety of factors you can look at when you have ambiguity in your ordinance, right? You can look at the purposes of the ordinance, you can look at the other provisions in the ordinance, and there also is, a principle of law that generally says that zoning is a derogation of rights, of property rights, and so if there's an ambiguity in a zoning ordinance, that the tie goes to the landowner. That is also another, I'm sure that Attorney Mazur would not disagree with me about that. The question of where you land on ambiguity, whether it's ambiguous, and whether the other provisions in this ordinance would control over that. Again, all of that's up to you.
I guess I'd encourage you all to look at section 7 if you haven't yet.
I don't have it with me, I don't think.
I'll read it. It says, conflicts with other ordinances. Whenever a provision of this ordinance conflicts with or is inconsistent with another provision of this ordinance or of any other ordinance, regulation, or statute administered by the town, the more restrictive provision shall control unless the state shoreline zoning law provides otherwise. So it does appear to conflict with state zoning, but I'm not sure if control. See, this almost seems to exclude state zoning from consideration. It's unless, and almost the way it reads to me, is that state zoning law, if it was less restrictive, would apply, not more restrictive.
Ned, what does restrictive mean in that case? Is it? Whose point of view? It's whose point,
Right,
you know,
right.
whose point of view?
I think common sense, I think to me says the restrictions are the restrictions placed on the landowner. Steve?
You know, we're looking at a town with over 200 miles of shore frontage, and there's non-conforming lots all over the place, especially in smaller areas. To me, it was the wisdom of the people who put in the sliding scale to cover an instance just like this. And the math is right there. So, personally, we'll come out. I have no problem with this because people thought this out, and it's right there, so.
I might argue with how much they thought about it.
Okay, maybe the wording,
They
but,
couldn't write
No,
it.
yeah, we can talk about the wording,
Yeah,
all
I
right.
think I'm,
but that was where I'm coming from.
yeah, my inclination is to
That's-
give the applicant the benefit of the doubt as far as the calculations. Right, whether to consider one side or other side or both. I think, I think it's ambiguous enough that I would give them the benefit of the doubt on that. Where I'm struggling is more whether this actually conflicts with other provisions in the ordinance.
So, who's going to, oh, well, all right.
No, go ahead. This is
There's-
supposed to,
As we know, there's conflicting language
right, right.
just about every.
Well, I'm not,
case we have.
I'm not,
Who's
I'm
going
not-
to appeal?
Define the conflict for me in the statement that either one side or the other, a row of properties. I don't see it as a conflict so much as an ill-worded, if you wanted it to be on both sides, surrounding, as Amy pointed out, that's what should have been said. But the minute I read that, my first impression was either side, you got your pick.
you get to choose.
You get to choose. So I agree with you, Steve, that to me, this one goes.
It's the nature of the area down there, if you know Lookout Point, and
Well, if you walk past the
there's
neighbors.
non-conforming lots all over the place.
I think either makes sense for the way they're interpreting it. What if you had a lot that was adjacent to Brunswick? And would you take into consider, and that was your border? And would you go look at Brunswick lots and look at how they measure them? I think either gives you that flexibility to look at one side or the other.
It does.
Yeah,
Would you like to add anything? Try to clarify this for us? Or?
Well, I don't want to undo your conversation, but a couple of, and this may add to a little bit of the ambiguity on a couple fronts. One, when we looked at this language, and again, I think we have all admitted it's not worded well. I think part of the way we looked at it is to Attorney Chow's point. You want to, I think I'm going to use this one instead. You want to fit in with the neighborhood. So to go beyond, I think it does give the flexibility. So you do fit into the neighborhood. So we're not creating something way different. So it's when it says either, you're looking at the neighborhood generally, and it gives the ability for that choice to the benefit of somebody in this situation. I would also argue on the other point about the nonconformity. We're not typically, when you're looking at nonconformity, we're not increasing the nonconformity. We're not asking to change the use of the inn. We're not asking to change anything currently there. Yes, we're splitting it into two lots. We feel as though both of those lots meet those standards. So I think you guys are all, I appreciate the discussion. I did just want to, and I tried to talk to Attorney Chow. In terms of the conflict, I guess we're viewing it as an interpretation issue and the board assisting the CEO. I'm not seeing, it, from my perspective, a conflict. I think to board member Lawson's point, it's really, I think, an interpretation issue on the ambiguity.
I guess my thought on the nonconformity on Lot 40 is, and that was the reason for my question, is a interior lot that's actually in the shoreline zone but has no frontage, a nonconforming lot or not. If it is, then we are creating we are increasing the nonconformity of Lot 40.
I think that's when you do get into the use, though, because you can arguably under that, I think it was slide 4 where we had it. It does anticipate lots with no, it's that commercial uses, but it does anticipate lots with zero frontage. So I think it would be a case-by-case basis.
Can you point to that?
So within that, on chart 4,
Yeah.
in 15.1, so within the shoreland zone adjacent to tidal areas zoned for commercial fisheries 1 and 2, for commercial uses only, the minimum shore frontage is none. So you may still have some, I'm not saying you don't have non-conforming back lots, but it does have some anticipation of.
A commercial lot,
A
you're
commer-
saying a commercial lot
Commercial.
does not require frontage.
Right, none.
This is not
None, yeah,
nonconforming.
so it's not a perfect system, but I don't want you to think all of your shoreland zoning backlots are necessarily non-conforming.
Yeah.
They may be, but
Yeah, what do you suppose the purpose of that is?
I just wanted to ask a couple of questions that I hope lead us in the same direction we're discussing. First was, when we used the calculations, we used the residential lots. So we did use one on one side and one on the other because those were all residential lots. So we averaged residential lots and didn't consider Mitchell Field because it is non-residential and has been, you
It's
know.
a unique situation.
It's unique, and the town has chosen for it not to be residential, and I don't think the federal government will allow it to be residential either, but that's a whole other point. And my other question is, and I think, to the point, you can create a lot in the shoreland zone that doesn't have frontage. It happens all the time. And it may be behind other lots.
Right.
And be partially in the shoreland zone and not have shore frontage. And actually, I don't want to sound like a wise guy, but I thought of an example, which I actually know, I won't give you the same dimensions. I know it exists in other places in town in at least one instance and maybe more, where you have a much larger parcel that goes all the way from the shore to the road and only has, say, 100, 140 feet of frontage, but you may have 10, 30, 40 acres. Are we saying that we can't divide that lot at all because it's non-conforming as frontage? Because if you can no longer divide the lot? I mean, I think it's the same situation on a different scale.
What are we thinking here?
I told you, I was,
Yeah, and I think I told you what I was
Yeah,
thinking, and I haven't changed it. I've divided land here with the help of a surveyor, or 2 or 3, depending on what was going on. And all of these get down to tricky. You've got to hold the hands of the codes office. And the codes office has told us why they didn't approve this. They want us to make this decision. So
I think it was a good call by the CEO.
I think it was too.
I agree,
Yeah,
I agree.
just said
I think I think it's in the right place.
I hate
Yeah.
to say that.
Yeah,
But I think a decision here will set a precedent for the future and the use of that 15.1.3. It's flexible, it's difficult to interpret, but I think any decision here will set a precedent for future. And I think that's important.
That's,
We are,
we don't set precedent.
No,
But the
well,
math has to work.
but
And
the
if
I
decision,
guess
the
I
math
wanna-
the
doesn't work,
decision will set,
then it doesn't work.
No,
No.
that's actually not true for this
Yeah.
board. Because we don't, we could do the complete opposite next.
Yeah.
month. I mean, we shouldn't.
That would-
And I
that would
agree
really
with you
be a
that- Yeah,
nightmare.
no,
Well,
I understand, but legally
Yes.
speaking, we
we
don't
don't
make
set
precedent.
Yeah. We're,
okay.
A future
That was
board,
not a good.
a future board
that
is
was
not,
not a
no,
good
we
word.
understand what you're
a
saying.
future
now.
board is not bound by
Good.
any decision that we make.
Do you want me to?
Could I
read
ask,
something?
maybe Margaret or Amy, have you seen a sliding scale like this in other ordinances? Shoreline zone
This
ordinance?
is the first time I've seen it.
Okay.
And I don't think DEP would, I mean, I'll let Margaret speak to what the town may wish to do with this provision. It is in your ordinance today.
Hi, Margaret McIntyre with the Planning Office. When this first came up, we did reach out to Jeff Kalinich from Maine DEP. He's one of the shoreline zoning coordinators. And we often look to him for guidance first because he works with shoreline zoning ordinances every day. And it's free guidance. And so we did first reach out to him and I emailed him and I said, well, what do you know about this? And it's not in chapter 1000, it is, which is the, the municipal shoreline zoning guidelines from the state. So sliding scale of frontage isn't in chapter 1000 and he couldn't find it in his records and he suspected that if it did come from the municipal shoreline zoning guidelines, it was predated when the DEP had that project. So it's really old if it came from them at all. So it was not really any help trying to interpret it, but we did try that first.
Thank you.
Someplace else there's a sliding scale, because I've run into it before. Not on water frontage, not on shoreline frontage. It was on, I believe, height.
It's used in other zonings in heights and in front setbacks.
Yep.
Averaging houses on each side to determine the front setback.
Well, there's,
In fact, it was on that road. It was one of those houses on that road wanted to do something. I don't think
Well, we
Tim was
were, had an appeal, right? Is that the
Yeah.
height?
yes,
oh, yeah.
It was one of the houses around.
one of the houses that, oh, here, yeah,
Oh, right, right.
Yeah.
right, That's right.
okay, but
Um,
that's neither here nor
Yeah,
there.
no,
on-
I mean,
on
I think there
shoreline.
is some, another example of sliding scale, isn't there something in the subdivision ordinance for open space? That if you create some open space, then you can have a reduction in lot size. I think there is.
Yeah, I
that's
think there is
another
on that
example,
too.
but-
Tim would be
and
the
but
one
I
to
don't- yeah,
ask
That has
him.
nothing to do with this.
But- Right,
Okay. Well, it sounds like we're,
would you like a move?
well, I think
Oh,
we
do
need
you
to go
want-
through we need to walk
Yes, we
through
do.
this stuff. And this is, I will note, this is a de novo hearing, so we have to treat this as though we are the codes office. So I think,
Does anybody else want to say anything?
is there anybody else who wants to speak on this? No?
Hi, Margaret again. I would just note that we did look up when this lot was split in 90, 92 or something. And the frontage requirement was 100 feet at that time, so it is legally conforming from shoreline zoning at that time.
Okay, thanks, Margaret.
So the standards that we need to apply, I guess the first thing, well, I guess one thing we should confirm too, I suppose, is that this is not subject to subdivision. Is that correct? What would, Margaret, can you speak to that? What would trigger, what would trigger the subdivision ordinance?
That's not- the lot's too small.
This is probably a question better answered by Amy. But if you had 3 or more uses or dwelling units or lot splits within 5 years.
So then this clearly has not been,
I wouldn't say so, no, because
Well,
there's one existing use. We would add maybe 1 use and 1 lot split, so, yeah.
okay. So I guess the first motion I would make is that we do not need to consider subdivision ordinance in this because, you know, well, based on what Margaret has just explained to us.
Okay,
Is there a second?
second.
All in favor? Motion carries 5-0. And I think we can jump directly to the shoreline zoning ordinance. I'm not aware of any other controlling ordinances. And I think we go right to the section 15, the land use standards, and 15.1, the minimum lot area, shore frontage, and lot width standards. And I guess the first motion I would make is that the proposed lot does not meet, what's the exact? Does not meet the minimum lot. It meets the minimum lot area, but does not meet the minimum shore frontage. I'm not talking about the exception yet, I'm just talking about the table, 15.1. By, according to what 15.1 says, this does not meet the minimum lot standards.
Oh.
That's a motion.
Why do we need that? No, I don't understand.
Yeah, I don't understand why we need it either.
Why do we
Because we're
need
supposed to
that?
be the codes office, and we're supposed to dot on.
Oh, de novo. Okay,
We're
yes.
supposed to go through the whole thing.
Yeah, we have to go
right?
through the whole.
So that would be
moved.
the first step that the codes office would have
Okay.
taken, is that, oh, I'm looking at the
Right.
table, it does not meet the
Right.
standards as set out in the table.
So moved.
Is there a second? Any discussion? All in favor?
Uh-oh.
Did you want to add something, Amy?
I was just thinking in terms of your deliberations.
Yes.
I think it's fine what you've moved, that it does not meet the minimum shore frontage table in 15.1. Are you getting to the question of
Then-
whether
then we're gonna take up whether-
15.1.3
Whether
applies?
the exception applies.
Okay.
Are we there yet?
No discussion? All in favor?
Yeah.
Motion carries
Okay,
5-0.
all right,
So now we go to
15 point.
the notes, which
Yeah.
says, see section 15.1.3 for sliding scale regarding frontage. And regarding 15.1.3, I would move that the applicant has demonstrated that they meet the requirements of the sliding scale exception spelled out in section 15.1.3.
So moved.
Is there a second? Discussion? Yeah, I guess I think what it comes down to me is the ambiguity.
Yeah.
I think we need to interpret this in favor of the applicant.
I do too.
I think, I think these two things are in conflict, but as Steve said, town meeting, this is what they voted on, this is what we're stuck with. Personally, I don't like it. You know, I don't like the language, and I guess I'm editorializing here, I don't like the provision, but it's, I think, to my mind, it's what the ordinance says. So
Yes. Yeah,
I
I
would
do too.
move.
And the math works. They demonstrated the math.
Yeah.
So that, knocked it out for me, or both ways, the way they did it, at least from what their interpretation was.
Do you have a comment, Amy?
I just want, just in terms of drafting notice of
Yeah.
decision, do you want to be more specific?
I would-
With respect to, I've written that you've demonstrated they meet the sliding scale standard. Are you going to reference the 3 lots to the left, southwest? Sorry, I got my directions wrong. I think it's lots 32, 34, and
Yeah.
38, which average, I think that the average there is 114.
I'll
Is
amend the
that-
motion.
Is there a consensus?
Would
that
you
that's-
advise to do that, to add that into the motion?
I think it's just
I think
helpful
it's
in
good,
terms
yeah.
of describing the basis of your decision, what facts you're relying on from the application.
Yep.
It's not absolutely necessary, but if
Yeah,
you're clear
I'll
about.
try to clarify what my thinking is. Pat?
Should we address the word either being, I don't see it as a conflict. I see it just being inadequate to, well, allows a lot of leeway.
It does. Well, that's the point of that's my point about the ambiguity. It just doesn't really spell out clearly what you should be doing, and we're giving the applicant the benefit of that ambiguity.
Yeah, by one word, it doesn't.
I'll restate the motion. I will move that the applicant has demonstrated that they meet the requirements of 15.1.3 by virtue of the fact that lots, the average shoreline of lots 38, 34, and 32 average out to less than 150 feet and allow the applicant to establish a lot
Okay.
with a full
Yeah.
frontage between 100 and 150 feet.
Okay, so move.
Second? All in favor? Any discussion? All in favor? Motion carries 5-0.
God.
And,
Do we need a final motion to?
well, I
instruct the
just want to make
code
sure we've covered everything. I don't think there's anything else we don't need to go any further, I don't think, with the, there are no other, as far as I'm aware, I guess I'll make a motion that there are no other standards that we need to apply to this.
Okay, and therefore, we'd ask the codes office to,
Well, maybe we'll make that as part of the final.
final one, okay, yes.
So, yeah, I would
Yeah.
move that,
Okay,
There
I'll
are-
second.
that the rest of 15.1 does not apply.
Right.
It's,
I'll second that.
All in favor? Motion carries 5-0. And then, well, maybe we can ask, what do you think, should we just direct the codes office to, well, the codes office really doesn't do anything, the codes office ignores it, right? This is our interpretation, and the codes office should follow that. Yeah, so I would move that the codes office, when this comes back to them in the form of a deed or plan, that they not object to it.
Okay, so move.
Second.
Second, all in favor? Motion carries.
Okay.
Amy, is there anything else that you think we should cover here? Okay.
One question is, do you wish to stay, so you can vote, once you're done with your deliberations, and legally you have 7 days to issue the written notice of decision that's consistent with your vote. I know what your normal practice is, if you'd like me to draft that, I can, if you want to do it as well as you can, it's fairly straightforward, but if you wanted to delay, you can get your draft notice of decision in the next couple days. He does. But if you were to do it that way, I would recommend that you move to authorize you then to sign it on behalf of the board, whatever your decision is.
We've been,
I don't know what you want.
we normally sign it all because our previous town attorney said we couldn't do that. We tried to get, yeah, we tried to simplify things by doing that
Well,
in the
you
past.
definitely would want to duly authorize the chair. I think either way is,
Yeah.
it is safer to have everybody sign, but I think in some instances it's okay to have the chair.
I
sign.
would prefer to do that, if you think that's fine.
I think if you do it, but I think you have to do it by motion.
Yeah, okay.
Our chairman writes a mean notice of decision.
You're done.
I will move that the board authorize the chair to sign the notice decision once it's been completed by the town's attorney.
So move.
Second? All in favor? Motion carries. I think, folks, we granted you everything you want. I will note that there is, although I don't see anybody here that's likely to appeal this, but that you do have certain rights of appeal and also the right to ask us for reconsideration. But I think we're all set.
Thank you very much.
Yep, thank you.
Just get it done before the town changes the ordinance.
Yeah, get it signed. Amy, thank you. Because when you do what you do and then try to go a little further, that's always helpful.
Good luck, folks.
Best of luck to both of you.
Yeah, good luck.
Yeah, they still have to get a building. They haven't gotten the building permit.
You're welcome.
When you get, no, go ahead. I got a question, Amy, when you get a minute.
I can't wait to see the building envelope.
Right,
I'm sorry?
I can't wait to see the building
right.
envelope
Yeah.
because of the stream.
I mean, is that really a stream?
No one was here.
I'm not sure it's a stream myself.
I mean,
but I'm not,
that's going to be some
Not up on
little
that.
reflection. to-
more like a drainage
board.
ditch to me. I think a stream's
You know,
supposed
it
to have
makes a
a
difference.
gravel bottom.
If there's somebody
Sort of running across the lawn.
complaining about A, B, C.
I don't know. I'm sure you run into a lot more
Road sweeper.
sticky situations, but,
Well, we'll see what Tim says.
if I can find my agenda, well, I think the next item was,
We elect you the chairman.
no, you don't.
What?
Let's do the minutes.
Oh, that isn't, oh,
I read the minutes. They were very, very well done. I didn't have any objections or changes, so I would move that we accept the minutes as drafted.
so move.
Second. All in favor? Motion carries. Election of officers. Who wants to be chair?
Not I.
Somebody's gonna have to be.
Not I.
You're giving up
I'm
the chair?
done.
Yeah.
I nominate Ned Simmons. You can.
What
second
did-
that.
What did Richard, what did Lyndon Johnson say? I will neither accept
Yes.
nor,
Yeah.
or neither seek nor accept the nomination.
I nominate Dave Z.
That's a dirty trick.
Oh, that's naughty.
So you're serious?
I'm
You
serious.
do not want to, okay, I'm serious.
What did he say? I don't,
He's,
I
he's,
can't hear out of this ear.
don't bother nominating him. He's not going to do it next year, going forward.
You're not going to be on the Board of Appeals?
I'm continuing on the Board of Appeals.
But not as chairman.
Not as chair. I think somebody else needs to.
Then Dave's not here, so it's going to be Dave. Right? Isn't that what
We
you?
can postpone this
I think we need to.
until, well, I don't think we should postpone it until there's another case. We could have a meeting.
No, I was just kidding.
Yeah,
We could have a meeting just to decide and
That's-
decide when
that's
everybody's
fine.
here.
but yes, everyone needs to be here, I think. Otherwise, I'm going to nominate him again.
Well, you can nominate him when it's to his face.
I'd rather do that.
All right, so we'll
And then,
postpone that and schedule a meeting, I suppose, the next month, the next regular scheduled time.
Is
We'll
it-
have a
it
meeting.
doesn't
some-
even have to be there.
Is your
does it?
decision something to do with the personalities on the board right now?
No, it's because I'm reaching the age when I figure I should be running for president.
Oh, very,
They're not that old, right?
I sure am.
very dry.
No comment.
Right, that's right.
Uh-oh.
I just wanted to suggest, if you guys are going to postpone this election of officers to the next meeting, I had reached out to Amy Chow to do kind of just a catch-up sort of training with the Board of Appeals, based on, I think, a comment that Ned had made. So maybe we could do all of that at the same time. If,
Oh.
maybe she
Great.
wanted to schedule something, we could all meet up and you guys can discuss the election of officers at the same time.
That sounds like
Okay.
a great plan.
Yep.
I'm not gonna,
Not
you know,
gonna do it.
whoever takes it over, I'm willing to help them as much as I can. I'll give them my cheat sheet that I wrote down 20 years ago here, starting the meeting and so on, but
How many years have you done the chair?
I don't even know.
It's been quite a while.
It's been over 20. I
So
think.
this is a youth movement we're looking for here?
Yeah, yeah.
Well, if we're gonna look for a
Well,
youth.
that
movement,
eliminates
I think we
me.
better get some youth.
That's great.
Youth.
Okay, we're done with, I mean, are you all set, Amy?
Are you adjourned?
We aren't yet.
Oh, we
I mean,
haven't
if you're-
yet.
If you're all
Did-
set,
Did we vote on the minutes?
we did,
Oh, we
we
did.
did, yeah.
Just wanted to, we can confer when you're adjourned.
All right, we're adjourned.
Okay.
No, well, I move that we adjourn.
Okay.
No.
80,
Need a motion.
8:02, 8:03. I got
You can shut us off, Mary Ann.